Hello, and welcome to CSIS for a conversation on digital policy and human rights considerations in Ukraine. I'm Caitlin Chin-Rothmann. I'm a fellow with the Strategic Technologies program at CSIS, and I'll be moderating today's conversation. Today's panel comes amid a profound digital transformation that Ukraine has undergone in just half a decade. In 2019, it established the Ministry of Digital Transformation. In 2020, it launched DIA, a mobile app that approximately 20 million Ukrainians now use to access government services online. Today, Ukraine is one of the most technologically advanced countries in the world. Online tools have brought significant economic benefits and have offered a new level of convenience and accessibility for many citizens, especially after major disruptions like the breakout of COVID-19 in 2020 and Russia's full-scale invasion in 2022. However, technological advancements in any society require policy dialogues on how to protect fundamental human rights like privacy and digital inclusion, and these are important long-term considerations that will extend into Ukraine's post-war reconstruction period as well. This is also the topic of a new report by the CSIS Human Rights Initiative and the CSIS Strategic Technologies Program, which was made possible by the Open Society Foundations and is now available on the CSIS website. And today's event will dive into all of these topics. Now, I'd like to introduce the rest of the panelists who are experts in digital transformation and the policy challenges and solutions that come with it. Here in the room with me today, we have Gulsanna Mamediieva, who is an adjunct professor and a tech and public policy fellow with the Better Government Lab at Georgetown University's McCourt School of Public Policy, as well as an advisor to the Vice Prime Minister for Innovations, Development of Education, Science and Technologies under the Ministry of Digital Transformation of Ukraine. Joining us remotely from Kyiv, we have Tetiana Avdieieva, a senior legal counsel at the Digital Security Lab Ukraine and a member of the Ministry of Digital Transformation's Expert Committee on AI. And then also joining us remotely from London is Lucie Audibert, who is a senior lawyer and legal officer at Privacy International. I want to remind everybody that we are accepting audience questions, so please submit your questions through the event page on the CSIS website. I will be tracking the questions on my phone, and we will get to as many as we can. So, Gulsanna, I'd like to kick off the conversation with you. With the launch of DIA, Ukraine has become one of the first countries in the world to pioneer this concept of a state in the smartphone, which is a completely digital platform for people to access everything from birth certificates to child support to tax filings completely remotely. And on one hand, electronic government services and database are critical for Ukrainians, especially for those who might not have access to in-person services. But e-government also introduces the possibility of cyber attacks, which require a very high level of digital resilience to counteract. So could you tell us about how Ukraine has protected critical systems and administrative data during the war, and how it can continue to maintain long-term cybersecurity after the war ends?
Thank you very much for this question. As you rightly mentioned, that Ukraine started digital transformation in 2019, like rapid digital transformation, yes, when it became central in the policy of Ukraine. We didn't start from zero. Of course, there was already something, like quite solid basis. Still, Ukraine maybe started later than most of the European countries, but it also gave us leverage to use, best technologies, the last word of the technology, and learn the lessons. And it's important to understand that Ukraine was building this digital public infrastructure during the war already, because the Russia occupied Crimea in 10 years ago, 2014. So we were designing the system secure. It was built secure by design because it was built actually during the war, during the conflict, with a big aggressor and a big country as Russia. And this is it's important to understand this fact because it's really designed the way how we were thinking and how the system were built. When I speak about secure by design, basically the first thing that I mean that its whole system is decentralized and the storage of data is diversified, meaning that there's no any central database that collect and it was made so for purpose, and it's proved to be the best practice in the many countries. So we learned from, for example, from Estonia, we took their X-Road system of interoperability between the registers, but we were in the condition that we had to add and think about security and the cryptography, and Ukrainian expertise and tech talent that we have and lucky to have in national expertise allowed us to enhance and build even more modern system, and it's called Trimbita. So basically, very simply saying that all data in Ukraine is stored in different kind of registers, which they are very decentralized. There are many of them, and how the enabler of all this innovation in the government and convenience, I would say the foundation is basically Trimbita, the system that allows securely interchange and exchange information between data when there is proper legal ground for this. This is kind of architecture that was in place in building digital public infrastructure. And of course, during the war, there was numerous measures in place, and if I may very shortly say several of them. So we were in a position that we have to concentrate and increase cybersecurity efforts and defense around critical infrastructure and government services, like building advanced firewalls, detection of the interference activities, conducting regular audits, but also international cooperation. We received enormous support from our allies in terms of technical assistance, even equipment, and also intelligence sharing information. So we were more prepared. Data backups. Ukraine now actually using data backups for the critical data. We use cloud for government services and the essential data, and have an opportunity to quickly restore if in case cyber attack will be successful and impact. But there was no case until now. So I think Ukrainian system proved to be secure enough to stand. So this is a kind of a main pillars. And of course, we shouldn't underestimate the trainings, the regular trainings, and how the digital transformation put digital skills and enhancing in digital skills among the regular population, but also government employees at the center. So we have a really big national program. It's called de-education, but also other to educate and train about cybersecurity and make people aware about all the threats and how to, simple measures to prevent them.
In addition to the digitization of administrative functions like tax filings or business registrations, we've also seen the government adopt wartime technologies to enhance security and defense. So this includes facial recognition databases like Clearview AI, as well as the deployment of video cameras in public places or citizen reporting mechanisms, including through DIA, which allow people to report potential Russian troops or spies through a mobile app. So maybe I can start with Tetiana first and then move to Lucie. I want to ask, first of all, does this raise privacy considerations? And then second, after the war is over and once Ukraine transitions into the reconstruction period, how can government, civil society, and the general public balance this need to protect both privacy and security in the long term?
Actually, thank you very much for this question. It's a topic for the heated debate currently, both in Ukraine and on international arena. And generally, the development of such technologies concerns not only one particular country which is in the state of the war, but also those which are collaborating in the sphere of technology, in the sphere of economy, exchange of experience, because many technologies currently are actually of dual use. But before diving deeper into that, the thing I always start with is the understanding of the legal landscape, because it is very important to get that we cannot, by default, apply international human rights standards without any modification to the country which is in the state of war. So we have the regime of derogations from international obligations when it concerns the application of European Convention on Human Rights and International Covenant on Civil and Political Rights, as well as we have the martial law regime, which also establishes particular limitations. And through this prism, we actually have to analyze any kind of technology which is applied currently in Ukraine. That is an important precondition, like to start from. But when we dive deeper into the kind of technologies, what personally concerns me is the tendency of making amendments to Ukrainian laws. For example, the Code of Criminal Procedure allowing law enforcement agencies to get access to the cameras with video, which are doing video surveillance in the streets without any additional safeguard, for example, without the court order. And the danger here is when such amendments are made, are introduced by the government, by the legislator, not only for the martial law period, but for the entire period, while this norm is active. So that is kind of the dangerous tendency, and we are currently working in the sphere of advocacy to amend it and to reformulate it in order for the safeguards to be put there. But generally, what I want to say about the video cameras in public places, facial recognition and related technologies, it is very important to ensure that we have a transition period strategy, namely that we have the line been drawn between the martial law application when additional limitations on human rights are permissible and the period of peace times, because all of us apparently hope that after Ukrainian victory, the renovation will start at the very same day in terms of rebuilding the legal system, rebuilding the physical infrastructure, and so on and so forth. So it is very important to ensure that human rights standards which are designed for peace times will be there at that time, and that the effective strategy will be drafted. Among the concerns which probably we do not yet have the solution for this problem, it is the one I mentioned at the very beginning of my intervention. It is the technology of dual use. Namely, what to do with technologies which can easily migrate from military sphere to civilian sphere, what the safeguards can be, what the safeguards should be, which is more important, and how to ensure their proper application. We also had a big discourse among civil society, both among civil society and with Ukrainian government, regarding the application of the Clearview AI technology. Apparently, because of its firstly overly intrusive nature, and currently there is even a bigger problem. I suppose we will discuss it in a little bit more detail during the next round of questions, but there are problems with Euro integration. The very mentioned AI Act prohibits, at least the latest version of it, prohibits scrapping of personal data. And in case we are supposed to proceed with application of Clearview AI, there would be problems with Euro integration because the entire technology is built upon the scrapping of personal data of individuals from all the available resources. So there are lots of issues to be addressed, but the thing which I'm actually it's the positive thing to bring to the table, actually, which I'm really satisfied with, is the fact that we are moving away from Russian technologies, Russian software and related things, because previously, and there was a big research of Ukrainian journalistic organization CSIS, who revealed that many municipal councils were actually using video surveillance, which was based on Trasir. If you don't know what's that, the brief explanation, it is the software which comes from Russia and has lots of concerns regarding both privacy and technical security. After this investigation done by Ukrainian media, there were changes into the application of that software. Namely, it was removed from the video surveillance system. And currently, the big project towards reviewing what is currently going on in video surveillance sphere is also on its way. So that's what actually makes it better in terms of we finally started thinking about the security side, and the steps are done in that direction. So there are both. I mean, there are things to work on, and there are things which we have already achieved. And I'm very proud of Ukrainian government and Ukrainian civil society doing those things.
So I do want to touch upon EU integration, but maybe I can get back to that word that you mentioned, Tetiana, which is safeguards. And with any democratic government and society, the deployment of surveillance technologies must come with reasonable guardrails to protect privacy and civil liberties. Now, Ukraine has been in the process of updating its privacy legal framework for a few years now. So maybe we could start with Lucie. As Ukraine looks ahead to its digital future after the war, what types of privacy guardrails and processes will become most important to prevent the dual-use secondary uses that Tetiana mentioned in this new modern age of data collection, but then also comply with existing human rights frameworks around the world?
Thank you very much, and thank you, Tetiana, for setting the scene so beautifully. Maybe I'll start with just saying that I always want to be a bit wary about the after the war language, because harm from unrestrained deployments of technology and data processing can come from very current uses. And the infrastructures that we set in place today will have significant consequences for the future as well. So there's obvious harm that can come from unrestrained and unaccountable military use of technology, obviously, such as misidentification if you use facial recognition technology, but also surveillance of citizens beyond military needs. So unrestrained surveillance capabilities in general society for military needs can easily be abused. Let's say if you want to use some kinds of surveillance technology to identify Russian infiltrates, but then use it to identify anyone who's critical of the regime. And then, yes, there's martial law, but the use of technology outside of martial objectives, like in a civilian context, can also be subject to non-martial law rules. And this is how we can ensure that what is necessary for the war effort is not abused in a civilian context. The consequences of this are present, but also future. If you entrench harmful practices and create dependent infrastructures in the way, for example, that the government is becoming very dependent on Clearview software, but also influencing the future development of legal standards. So if you roll out certain kinds of invasive technologies beyond military purposes, you risk habituating your population to its use and its normalcy, such that legal frameworks will now and in the future be designed in order to allow the use of invasive surveillance technology. And so going to legal frameworks that can help prevent these issues. The first thing that obviously comes to mind is a copy-paste of the GDPR, which is what will have to happen at some point for EU integration. And this is what many countries in the world have been doing through, what we call the Brussels effect, where legislation on digital issues in the EU kind of end up being replicated elsewhere. But there's a risk of following Brussels blindly, first replicating any downsides to the current legal framework. Every European law has been developed in a very specific context of extremely diverse cultures and political negotiations. So we must be wary of not replicating issues elsewhere. But also there's a national security exemption because national security is outside of the EU's legislative mandate. And so we must turn to other laws that are not necessarily GDPR or data protection laws in general, because data protection law governing the protection of data and the practical obligations of data controllers isn't always sufficient to address harms beyond the pure processing of data. And so we need, as the title of this panel speaks well, a human rights approach to the use of technologies to prevent uses of technology that may not engage data protection law, but that may be harmful in other ways. And so obviously, as Tetiana mentioned, Ukraine is a member of the Council of Europe, a signatory to most of the international human rights law treaties. And so in that sense, is bound to follow the principles of legality, necessity, and proportionality. This should be the kind of guiding approach, including during the war effort. And Ukraine has indeed made valid derogations from its obligation under the European Convention of Human Rights and the International Covenant on Civic and Political Rights. But first, certain rights are not derogable, such as the prohibition of torture, forced labor, no punishment without law. And the thing is, many technologies can engage these rights as well. Technology doesn't just engage the right to privacy or the right to freedom of expression. Derogations must also follow the principles of necessity and proportionality. So these should always be guiding principles. And we must remember that derogations are temporary in nature. So they're renewed, of course, as long as the war continues, but Ukraine must ensure that it's not setting up systems that may contravene its obligations once the war is over. And then we must think about other types of laws as well, beyond data protection law and human rights law, that are key to regulating the use of data in national security and military contexts. We can have investigatory powers oversight laws that regulate mostly the conduct of intelligence agencies and security agencies, and just generally regulation of surveillance powers to regulate the conduct of state surveillance. And then, of course, in the current context, international humanitarian law can also be a guiding set of principles, because it regulates the conduct of war. And so we need to find ways in which technology can follow and comply with international humanitarian law. And so all of these, I think, are really key but different pieces of the puzzle when it comes to digital governance, both in war times, but also after the war.
Tetiana and Gulsanna, I wanted to ask if you have a follow-up to Lucie's point on EU integration. In addition to the GDPR that Lucie mentioned, the EU has already moved forward with other major digital regulations, for example, the Digital Services Act, and it is about to finalize the Artificial Intelligence Act, which could have implications for real-time biometric surveillance in public places. But there are challenges to Ukraine aligning its digital policies with the EU. First of all, Ukraine is already in a very advanced state of technological deployment, so it would be adopting these laws at a very different stage than EU member states. And then second, the accession process could potentially take years, and we don't know whether EU regulations would change in that time. So maybe we could first turn to Tetiana and then Gulsanna to share thoughts on how Ukraine can align its digital policies with the EU, just given all of the moving pieces that are happening.
So basically the issue always emerges when it concerns the newly adopted documents, because, for example, for Ukraine and for me as a participant of media law reform, it was much easier to implement documents which have a sustainable practice of implemented on the domestic level by various EU member states. For example, when you have the good examples, when you have the bad examples as well, you can relatively understand how the system would work in the best possible manner. And in this way, for example, Ukrainian law on media was drafted, and further it was recognized as the full implementation of Audiovisual Media Services Directive. On the other hand, when it concerns, for example, Digital Services Act or Digital Markets Act, there are already problems on the EU level regarding its implementation. For example, with German Network Enforcement Act, there are already some controversies. There are also problems regarding the implementation of those provisions in practice. For example, when various companies are starting to debate whether they shall be put on the list of LOBs or not. So for Ukraine, it is, since we do not have the access to European institutions, particularly European Commission, European Parliament, and the further big list of various European regulatory bodies, it is very important to understand the way how European documents, how European standards are implemented on the domestic level before proceeding with drafting our own laws. Because if regulations on the European level, which have the direct effect, namely they're applied directly after they are passed by the European Union, since they have the direct application, and any amendment also have the direct force and direct application for the EU state, it is easier for us every time the change is made, for example, because the document is cannot survive the practical environment, the current circumstances. Every time the change is made, we would be forced to amend the laws which we pass in order to align with the European legislation. So that's the thing we have to understand before actually rushing towards Euro integration and doing it with big steps, which might potentially be very dangerous in the long-term perspective. At the same time, if we are speaking of surveillance technologies, indeed the tendencies in the EU, which have been relatively extensively discussed today, are that real-time biometric surveillance is very much restricted, that scraping of personal data is prohibited, at least in the current version of the AI Act. In Ukraine currently, and that would be the brief update, for example, on what is going on in the AI sphere, we already have the roadmap of actions to be taken to legislatively regulate AI. We're already in the process of drafting the white book. It is done by the Ministry of Digital Transformation, but also with contributions from various stakeholders, including academia, civil society, independent experts, other governmental bodies, which are very active in the sphere of application of AI-driven tools. So there is a process of actually developing at least soft law regulation in order to give Ukrainian industry and foreign industry which enters Ukrainian market the understanding of the applicable standards and future standards to be applied. And the white book actually very seriously reflects the main key provisions of the future AI Act. So it means that step by step Ukraine is still doing is moving in that direction. Which is a very satisfying outcome of considering what we can actually do and considering our current stance as a candidate to the European Union. There are also various recommendations on application of AI, namely on AI and human rights, and also on responsible use of AI in the media. So since Ukraine cannot directly do that on the legislative level in various spheres, including surveillance, modern technologies, meal tech, etc. What currently is going on is development of soft law standards. And since Ukrainian industry, for example, in meal tech sphere, is united in the governmental cluster of Brave One, apparently there is an opportunity to coordinate the efforts and enforce those standards in terms of to follow them, to check whether other actors follow them, and to collaborate at least on the self-regulatory level, which is also kind of the good sign in terms of standards are still there, despite there is no possibility to actually put them in the format of the hard law. And also, the future step, as I mentioned previously, would be the exit strategy from the most dangerous kinds of technologies, I would say. The mentioned clear view, the related technologies which are of the purely meal tech use. We will need to develop the strategy for the transition period and also to draw the very solid red line in between what can be used in the civilian sphere and what shall be left purely for the military use. And even if it is developed by Ukrainian industry, it is still not applied against civilian people in Ukraine and can be, for example, only traded with Ukrainian partners, but again, with the reservation that it is a meal tech. And there are certain restrictions on its trans-border transfer, for example, no transfer to the states with a high index of human rights violation, and so on and so forth. But again, that is a future step to be done. And I would say that both in civil society, in academia, the colleagues of mine with whom I talked about the regulation of modern technologies, and also our colleagues from the ministries, relevant committees of Ukrainian parliament, we're currently discussing the idea of how to formulate the exit strategy and what approximate key points shall be included in order for it to be effective and human rights compliant.
A lot was said, and I can't agree more with everything that my colleagues in this panel mentioned. I was just probably would add that on a very abstract level, we see that that European EQ, it's not really designed for the system, for the situations Ukraine now is. That's why, like, even there was no full-scale invasion, working on like European integration, it required a lot of adaptation, and as Tetiana rightly mentioned, like to have opportunity to see what is working, what is not, and also apply this to Ukrainian context, which in technology sphere is honestly like very different than European one. For example, let's say the incentive from the big tech, to implement and be aligned with Ukrainian legislation is not so strong as with European acquis. So this is also some factors that we have to consider. And now it's even more complicated because the situation in the full-scale war is like changing the perspective that we look at. Ukraine is definitely looking into the understanding like what is going on the ground, and the mere fact that Ukraine is like actively participating in the Committee of Artificial Intelligence in the Council of Europe, and there is a group that constantly looking into this and international standards, how they are developed. We are in the constant collaboration with European colleagues in fostering, like very pushing into European integration. It's like our strategic priority. We also have to be cautious that we just not copy past the regulation and that it's not implemented, like not enforceable law or legislation in Ukrainian domain, as unfortunately we had experience with this kind of things when the law was kind of harmonized, but it was not really implementing in working in Ukraine. So now the question is, the first probably try to sum up is the question that European legislation, European acquis is not really, there are problems that should be reconsidered, and maybe Ukraine joining the European Union is a good chance for the EU actually reconsider the regulation itself in many spheres. This is really dynamic domain, and more dynamic than any other, for example, like agriculture. Yeah, also we see that even like Ukraine joining the agriculture market is forcing European Union to reconsider, like change the policies. The same way I think will go and like will be with regulating technology, use of technology in the public sector. I cannot say that European Union is, that Ukraine is should harmonize its legislation with European Union. It's kind of a joint process, should be, because there is a lot of space to improve in EU as well.
Yeah, it is a dynamic field in Ukraine, in the EU, and in the rest of the world. And I did want to ask about international standards, because Ukraine's digitalization and associated policy conversations is happening in the context of emerging technological and legal developments in the rest of the world, even outside the EU and Ukraine. Numerous governments are currently debating how to incorporate human rights standards into their digital frameworks, especially around artificial intelligence and facial recognition. And in addition to Council of Europe dialogues, Ukraine also attended the UK's AI Safety Summit in November and signed the Bletchley Declaration along with dozens of other governments. So I wanted to ask all of the panelists, how can Ukraine contribute to this growing discourse and dialogue around AI standards around the world, and vice versa? How might global developments affect Ukraine?
Maybe I can shortly step in here.
Sure.
For example, Ukraine also signed the Declaration of the Internet Freedom or something. I don't pretend that was led by US.
Yes.
I think it was 2 years ago.
Declaration on the Freedom of the Internet.
Yeah. So Ukraine is really, you see, there is a political will, and we see there's strategic importance to be on their, good side of and the good use of a technology. But regarding your question is that, let me put it this way: Ukraine now, unfortunately, is a lab for for innovation.
Mm-hmm.
In applying technology. All innovations in the world, if we think globally and historically, were happening in the emerging crisis situation, and was driven by military. Anything like GPS, data sharing, all the big platform that were built, and the innovation was driven by military. And now Ukraine is a lab for using the technology. If you think about the war in Ukraine, it's the biggest conflict in the cyber age. So many countries learn and look at Ukraine, what is happening there. I think one example is how shocking was, even for government in US, to see what's happening with Starlink and the use of in Ukraine. Yes, how the situation might turn to the point when one particular person, not elected, not a government official, deciding whether the military operation will continue or will stop. So this is a clear example what is going on and how other governments is looking, and the technology and the use of a technology changing not just powers between the government, but the powers between and the balance of these powers between the government and the industries. And yeah, so this is a point probably I want to stop, that we all in very interesting time when we have to learn, but should be very quick and cautious in reflecting and understanding.
If I can jump in, and to add to exactly that same point, there's obviously lots of other international forums debating digital governance to which Ukraine could contribute, but I don't think listing them right now would be particularly useful. But what I do think Ukraine's contribution could and should be is to be a leader in calling for human-centric regulation with evidence of conducting war and defense with continuing robust governance. And so even though Gulsanna is saying, and rightly so, that Ukraine has so far been a testing ground for new uses of technology and data in war, and a laboratory for tech companies that sometimes seek ungoverned innovation in order to build their products and services, I think it can and should also be a testing ground for human rights governance of technology in conflict contexts. And now is a key moment, an opportunity to have these discussions at a global level as these tools are being developed and deployed in other conflict contexts as well. And Ukraine could be a leader in engaging these conversations to show that it can effectively defend itself with modern tools without harmful consequences for civilians, without building a surveillance state, and without supporting the unrestrained and ungoverned development of dangerous tools. And Ukraine has already been a leading example of a privacy-preserving approach to biometrics collection for humanitarian purposes, for example. There's a great report by Human Rights Watch that showed that the Ukrainian government at the start of the war took a firm position against the collection of Ukrainians' biometrics by international organizations. And that obviously was informed by the litany of issues and failures that humanitarian data collection has done in the past decade, such as in Myanmar or in Afghanistan, when biometric data ended up in the hands of the Taliban, or with massive cyber attacks on the ICRC, etc. And Ukraine has been able to show that even though it refused this mass data collection by humanitarian agencies, it hasn't prevented proper administration of humanitarian assistance. Refugees were registered in other ways that were much more protective of their sensitive data. And even in contexts where biometric data collection is inevitable, safeguards can be put in place to confine the use of biometrics to the provision of assistance, ensuring that there's not then function creep and reuse of data for sharing with governments and other potentially malicious actors, and again following a necessary and proportionate approach to that. So yeah, I would obviously highly recommend reading that report by Human Rights Watch. And I think it's really a great example of how Ukraine can be a leader in that international digital governance.
So we will take audience questions, and I want to remind everybody to submit your questions through the Ask Questions Now button on the CSIS website. But I do have one more question for our panelists. So as we know, digital transformation brings tremendous benefits, whether economic, including when it comes to employment, or accessibility, including when it comes to government services. However, every country, including Ukraine, is still experiencing gaps in digital accessibility and digital literacy, especially when considering factors like age, a person's location, disability status, or other factors. So I wanted to ask, and I know that the Ministry of Digital Transformation has already undergone incredible initiatives to improve accessibility across the country, but how can Ukraine and other countries continue to make sure that the promises and benefits of technology are available to all?
If I may, there is really risk that technology can input into divide. Yeah, so citizens, the very fact that government is moving online and become more distant from citizens, it's problematic. I see on the practice when sometimes government is struggling to understand what are the real user needs, what are the problem, to see the journey that user make. For example, there was mentioned here the process of registration of internally displaced people in Ukraine. Now it's convenient and more like straightforward, but it was awful at some point when we had before full-scale invasion. It was really painful and I would say humiliating process. But it's very important for government to be user-centric in delivering the services and to understand this. Understand the real pain and needs. And one of those pain and needs actually is accessibility, that is not just, building the broadband coverage or providing everyone with proper and having a course about digital literacy. The goal is to reach everyone, and you have to build all services and in the government and policies and programs having in mind the most vulnerable population, those who haven't. And then if you build the program that is serving them, then all others would benefit. There will be many positive externalities. Of course, Ukraine is kind of I would say digital divide to me is also include trust. Because if you don't have a trust and confidence in your government, then it's also prevent you from using digital services. So it's not only skills, it's not only the technological equipment. You have a smartphone, you have internet, you also should have a trust to your government. It doesn't mean it shouldn't prevent government from working and going in digital, but you have to allocate a lot of resources and keep that in mind while building your services. It doesn't mean that you cannot change. I remember clearly when the flagship Ukrainian product was kind of softly say, not accepted by Ukrainian government, but Ukrainian society. But when we understood the feedback, the failures, communicated, a lot of measures were in place, and now I can surely say that the DIA is a love mark for Ukrainians. It's something that Ukrainians are proud, and because government try to work more in open and communicate honestly about what are the problems and how we're going to resolve it, and that we hear when it comes basically if anyone in Ukraine write a comment about some problem under the post of the Minister of Digital Transformation or any ministry that something is not working, the support will come to the place where they receive this command and critique. And we try to make sure that we will reply on all of this. And I think trust and confidence is a fundamental. When there is trust and confidence in the government services, it's likely that person will find a way to receive this, or family, grandchildren will help their grandma, and there's much more incentive to do this.
So I'm going to turn to an audience question now, and the question is, do you believe that private technology companies will continue their partnerships with Ukraine as the war continues? How can the private sector continue to support Ukraine's digitalization efforts?
I'm speaking too much, I think.
Well, probably I can start with this question. I would say that Indeed, it's very difficult for private companies who do that on rather voluntary pro bono basis to be involved into supporting of such a large state as Ukraine is for a prolonged period of time. But currently there are lots of initiatives, including the collaborations and partnerships with the Ministry for Digital Transformation, which actually enable those companies to get certain benefits. For example, comparing, as we already have talked today, comparing to the EU market, currently in Ukraine, there is no hard law regulation. And as Gulsanna rightfully mentioned, Ukraine is rather a laboratory for testing various tools. Therefore, many companies actually find it very beneficial to enter Ukrainian market, at least for a certain period of time, in order to test new technologies, find gaps, especially in the practical application in the field, and further on to update the software, for example, to change something in the approach towards designing the technology of a particular kind. And here I'm speaking not only of the surveillance technologies or any kind of meal tech, but of any kind of technology in general. For example, how to compose a database in case there is a total ban on scrapping of personal data and any kind of data. What can we do instead in order for the system to be effective, but at the same time not to violate the EU standards? And here Ukraine serves as a perfect ground to actually choose an approach, and in order for the technology to be well tested before entering the more regulated markets. There are lots of initiatives, for example, for foreign companies to join Ukrainian state projects in various areas, like in the area of economy, in the area of social support. There are also collaborations of Ukrainian custom service with foreign partners, and they're currently testing the AI-driven tools which enable them to label the products more effectively and much quicker than it was done before manually. So there are lots of different products. Many of them are actually not that well known, or for example not that large scale for everyone to hear of them on the certain period of their work, and they're more specialized. But I think still there is a possibility for various companies to enter Ukrainian market. It depends on the conditions, on their specialization and their priorities. For example, after the EU passes their AI Act or designs the way to implement DSA, some companies might decide to leave the EU market. But it's still the possibility to work in Ukraine in order to get in this period in between, while Ukraine still did not enter, still doesn't enter the EU market, in order to collaborate, test technologies, and understand how they can be designed in an adequate manner. Because still there is a big pressure, for example, from civil society to make everything which is going on currently in Ukraine human rights compliant, and the processes where Ukrainian government participates only proves that they follow this track, and they agree that the human rights and democracy and rule of law and all the other values which Europe supports shall be a priority. So I think that yes, there is, although companies might not that much work pro bono, there is still variety of options to collaborate on various levels.
So we have another audience question, and this is about trust. So e-governance solutions require a high level of trust from the public, and private companies also require trust that they will public confidence that they will not use personal information in ways that people do not want. How can Ukraine's public and private sectors increase trust in its data governance efforts?
I'm happy to take this one, at least for one aspect of it. So, as Tetiana said, I think there's lots of opportunities to have beneficial deployment of private sector initiatives in Ukraine at the moment. Putting aside the controversial companies like Palantir and Clearview that have entered the Ukrainian market, some would say to sanitize their image, which has been very much tarnished in some other countries. what I always like to call for is strict safeguards around any kind of public-private partnership in the technology sector. And we have at Privacy International developed such kinds of safeguards specifically for surveillance technology and any kind of mass processing of data that's deployed in collaboration between the public and private sector. And this is really, really key to both prevent harm, but also to build that trust, especially. And so if you build these kinds of safeguards around key public law and human rights principles of transparency, accountability, legality, necessity, proportionality, which are the usual human rights ones, and then oversight and redress, even in a conflict and war context, this is how you build systems that are transparent, accountable, and that can actually benefit people. And so examples of what these require is, strict scrutiny and assessment of the potential impacts of any technology deployment, ensuring, of course, compliance with all applicable laws, both, on the state and the private sector party. The designation of monitoring and oversight mechanisms, such as independent regulatory authorities. One key one that is often left aside, but very important, is to prevent locked dependence of the state that's purchasing or acquiring technology from a private actor, preventing dependence on the company's products and services, because this can have significant consequences if in the future the products don't work as expected or the state wants to move to something else. And obviously always providing for consultation of affected stakeholders and civil society whenever these kinds of systems are deployed, and providing redress mechanisms if things go wrong. And that requires clear assignation of responsibility to the various parties involved. And so I think that these kinds of principled safeguards is for me one of the key ways to make sure that these deployments happen with security and human rights in mind and build trust at the end of the day.
If I may shortly add to this, there's numerous research showing that effective delivering of the government actually contributing in building the trust. People feel respected, heard, that they matter, and government is taking care and doing their job. If government is not delivering or failing, or people experience a bad, uncomfortable, not engaged, and so on, then it's really influencing on the trust and confidence level, not only in technology but general to the government. And then it's have a really significant consequence and impact on democratic setting, because if you're not trusting government, you're not confident in your government, then there's less social activity, social participation. There is a clear, I don't remember the author of the research, but it's connecting the effectiveness of delivering government services with level how people participate in voting. So we also should keep this in mind, that building digital capacity and effective delivering government is important in building trust and confidence.
So I think we have time for maybe one or two more audience questions. This is another question from the audience asking about technological innovation itself. So prior to the war, what were the biggest challenges to improving digital innovation and further growing the robust IT sector in Ukraine? So they're asking, how has Ukraine worked to grow the IT sector? And besides the war, what are the biggest challenges that still lie ahead in improving innovation?
Well, I can briefly mention, and here would be a minute of PR of our research done in Digital Security Lab Ukraine. But recently we released a research on AI in public sector, and we also tried to do mapping of what was going on, like, for example, in 2019. And what is the point we reached currently now, like at the end of 2023. And what we identified was that there was a big problem of lack of digital skills in the public sector specifically, but this can also be found in various companies in private sector as well. So there was a problem that we cannot meaningfully implement new technologies, modern technologies, for example, automated tools and so on and so forth, just because people lack capacity, expert capacity, like technical skills, whatever, in order to monitor whether those technical tools are implemented in a proper manner in order to conduct a meaningful oversight regarding their compliance with the human rights, ethical standards, whatever. That was a big problem. I know that it is partly solved currently because there are lots of efforts on behalf of the Ministry for Digital Transformation, for example, in order to educate public servants, like civil servants, in order to educate those who are working on the central level in various ministries, in order to at least partly lift this problem, but it is still there. So it needs more efforts to be put into this in terms of education. And I think regarding market, probably Gulsanna is better placed to actually say, well, what's currently going on in that direction.
I would mention Ukraine has a really strong tech talent. The problem before the war, before full-scale invasion, was that if something is born in Ukraine, the innovative idea, it then kind of swoop out of Ukraine and incorporating somewhere in Europe or in like here in US. So we were thinking, and the overall problem is that developers and project managers, they will still be in Ukraine, the talent in Ukraine, but the product and the asset is incorporated somewhere else. And that there were several reasons why it was happening. So, and we can speak about like tax regulation, the risks with intellectual property protection, very old employment legislation, kind of not very old, but not adapted to the startup ecosystem. There was no modern legal instruments to manage and ensure protection of the investors who come, for example, from the Western countries. So it's legal and tax problems around incorporating and setting up a startup. So Ukrainian government created a special regime. It's called DSCD that was actually introduced 2 weeks before full-scale invasion to ensure its very favorable conditions to ensure that the proper legal tax intellectual property instruments are in place. In many places it was like replicating and learning from the, for example, UK legal system and introducing some instruments, for example, like earning shares by the founders of the startup that we learned, like US system. So basically this legal regime were introduced, and now it's I think close to 1,000 companies registered in the system. Like many of them are military tech, and its system evolve. Great opportunity for government to hear the problems tech and startup companies, startup and tech companies are facing in Ukraine and adjust. And Ukrainian IT sector is only one sector that continue to show growth during even the full-scale invasion. And it's amazing if you think about last winter, there was no energy, internet, connectivity problems, and IT company continued to develop and deliver to their customers who are abroad. So it's a kind of a combination. The problems, there is a clear sign that, a way forward to resolve these problems, which mainly lie in the regulation ecosystem. All other, we really have a tech talent. We have to just find a way how to support and cherish it.
Yeah. Thank you so much to everybody who submitted additional audience questions. Unfortunately, we are out of time, so we won't be able to get to all of them. I do want to encourage everybody to read our new CSIS report titled Ukraine's Rapid Digitalization, Human Rights, Risks and Opportunities in a Post-War Environment, which is now available on the CSIS website. I also want to take a moment to thank our expert panelists, Gulsanna, Lucie, and Tetiana for joining us at CSIS today and leaving us with a lot to think about. Thanks again to our audience for joining us, and we look forward to continuing this conversation.